Friends, hello and welcome to another episode of The Legal Breakdown. This is Jason Sansone with Sansone Howell Attorneys at Law, and I am excited to bring you a program today where we can talk about some very cutting-edge, brand new stuff. Today, we're going to talk about some laws that were passed to change the bankruptcy code, and this is less than 1 week old. We haven't even had a program since all of this happened. This is going to be our first opportunity to talk to you about it. So like always, we want to thank our host station, KTLV 1220 AM terrestrial radio here in Oklahoma City. You can listen to every episode of The Legal Breakdown on KTLV 1220 AM, or you can listen through the TuneIn radio app if you are outside of the geographic reach for KTLV 1220 AM's station. Alternatively, we simulcast actually, every episode by video on Facebook Live on the Sansone Howell Facebook page, and we record every episode and upload that both to YouTube for the video content as well as an audio podcast to Google Play, Spotify, and the Apple iTunes directory. So if you're not able to listen live, you want to catch it after the fact, there's lots of great options available. You can always check us out. So friends, what are we talking about? What has gone on? Well, bankruptcy, let's just be honest, it's not the most exciting thing to anybody, and therefore it's not going to be all that exciting to politicians. It's not an area of law that gets a whole lot of attention or excitement, very slow moving. We don't see a lot of Supreme Court cases. We don't see a lot of case law. We don't see many new laws being written or passed. In our world, the most recent exciting thing is BAP-CIPA, the Bankruptcy Abuse and Consumer Protection Act. People talk and act like it was yesterday, and yet that was 2005. It's been 14 years since BAP-CIPA shook up the landscape in bankruptcy. And to give you a little backstory in history, BAP-CIPA, again, bankruptcy abuse, was bought and paid for by the creditor industry, by credit card companies, that it was pushed through Congress and very much was anti-debtor, pro-business, pro-creditor. It took away, it limited a lot of the things that helped individuals. So I'm very excited and very pleased to be able to share that the laws we're going to talk about today are in fact positive to individuals. They're very pro-debtor, debtor-friendly, and that we're going to be able to see those out there to help. And so that's a bit of a difference. It's a shake-up from where we were 14 years ago. And so let's jump into what are these 4 laws we're going to talk about today. Number 1 is House Resolution 2336, H.R. 2336. It's really pretty straightforward. It's pretty simple. What this does is it raises the debt limits for Chapter 12 bankruptcies. Chapter 12 bankruptcies are limited to family farmers or fishermen. And now this doesn't affect the fisherman element of it, where in truthfulness it's very, very rarely utilized. Predominantly we're talking family farmers. And so the previous cap was $4.1 million. If your combined total aggregate debt, secured, unsecured, priority, didn't matter, exceeded $4.1 million, you are not eligible to seek relief under Chapter 12. You had to go for a full-blown Chapter 11. And the problems with that are obvious. That means more in attorney's fees, more in trustees' fees, more in filing fees, more complexity, greater length of time to your case, less protections. Chapter 12 is very specifically tailored to the family farmer. And when you take away the ability to utilize Chapter 12, you take away some of those protections that it was designed to enable. So this raises the debt limit from $4.1 million to $10 million. And it couldn't be more timely. This is a great time for this to occur because, unfortunately, the things that are happening in the United States, especially in the central United States when we talk about Oklahoma, Kansas, Nebraska, frankly, folks, we call these flyover states, but this is the heart of your farming and ranching in the United States. Your food comes from here, and these people are experiencing grave financial distress. That if we look at the year ending June 2019, so from the 1st of July 2018 through the last day of June 2019, when we look at Chapter 12 bankruptcies, Unfortunately, they have gone up considerably. That they were up 13% over the prior year in the United States, and that there was a total of 535 Chapter 12s filed in that 12-month period. So it's an increase of 60 bankruptcies from the prior period. That's the largest amount of Chapter 12 filings we've seen since 2012. And now you say, well, why 2012? What you have to understand is there's often a delay. There's a bullwhip curve effect to financial situations. So 2008 mortgage crisis happens. People get put in a crunch. We have all these financial woes. But that doesn't mean you see the spike in bankruptcies that day. No. You see the foreclosures, the spike in bankruptcies down the road because people were able to hold off creditors a while. Maybe they ran up credit cards, they battled it, they tried to make ends meet, they fought, and eventually the issues caught up. So 2012 was the peak of Chapter 12 filings as a result of the mortgage crisis. And now, folks, we are at a level higher than that for the first time since then. So that's very not good by any means. And like I said, we see a spike. The worst, though, is happening right here in our backyard. That Kansas had 13 more Chapter 12s filed than the prior year. That's up 50%, and they led the nation with 39 Chapter 12s. They're not the highest in the country, but one of the highest. It looks like they are number 2. Leading the United States in Chapter 12 filings was Kansas for this last year period. And then Oklahoma, while fortunately we didn't have nearly as many, we only had 14 Chapter 12s in that time frame, but we saw a doubling in the amount of cases that we had, that there were only 7 Chapter 12s in the prior year period, and now we see 14. It's small numbers, but it's big percentages. That's a 2x increase. So it shows you the woes that are happening in the family farmer industry. So it couldn't be more timely. It's great that Congress moved and acted and increased these debt limits to keep this specific chapter of relief, Chapter 12, available to family farmers. And so I think that's enough on that particular one. It's really straightforward, but I wanted to go a little into history and talk about why it's so timely and important. Number 2 in the 4 laws we're going to discuss today is H.R. 3304, House Resolution 3304. And I forgot to mention, I want to touch on, President Trump signed all 4 of these laws into law on August the 23rd. 3 of the 4 go into effect immediately. They don't have a delay clause. They're going to be enacted and official as of the signature of the president. Those are law of the land. The last one we're going to talk about does have a 180-day delay before the enactment becomes official. So when we get to the part talking about small business bankruptcies, you can't run out and use that just yet. Don't worry, we'll be gearing up and ready for it, but there's going to be a delay. But the rest of this is the law right now as we're talking about it. So going back, H.R. 3304, House Resolution 3304. This doesn't technically make new law. What it does is it extends the sunset clause on an older law. In 2008, Congress passed the National Guard and Reservist Debt Relief Act of 2008. And what that did is it created certain bankruptcy protections for individuals serving in the armed forces. There's already a lot of protections for those people that are on active duty military. What this did was it helped protect the National Guard and Reservist members. So if you are serving on active duty for 90 days or more, or if you're spending 90 days or more on what is defined as a homeland defense activity. So it doesn't have to necessarily be active duty. It could also be homeland defense activity. Either of those components, if you're 90 days or more and you're still on active duty, or if you had completed that 90-plus day activity within the 540 days prior to filing bankruptcy, then you are exempt from the means test. You don't have to do the normal financial qualifications for Chapter 7. You're exempt from that component, and you can file a Chapter 7 bankruptcy. So you're either on active duty during the 91 days or more 90 days, or it's within 540 days of the completion of that. National Guard or Reservist members. Originally, when this was passed, it was going to have a sunset clause of 3 years. And so what they did is they created it to automatically expire. So in 2008, it would have expired in 2011. That was extended. It's extended. So most recently, it was going to expire on December 19th of this year. Congress acted, extended it for another 4 years. So now these protections will expire December 19th, 2023. Now, folks, this is just stupidity in political football. There's no reason in the world they didn't make this a permanent portion of the law. If I was advocating any of our congressional delegation, you should make this a permanent portion of the law. It's silly that you keep extending it and saying it's going to expire at a different date and time. But hey, this is Washington gamesmanship and the give and take of our political parties. So whatever. We both know that in 2023, they're going to pass another resolution and extension continuing it because everyone wants to protect our armed forces members. It's politically popular regardless of the political party you're in. It's stupid that this has a sunset clause. It should just be the permanent law. Now, something that I consider near and dear to my heart because I've actually been lobbying and advocating for this next bill for quite some time, and I've never understood why it took so long to get this law. The law we're talking about is H.R. 2938, House Resolution 2938. Previously, before this was enacted, the only exemptions to the means test as far as sources of income goes were benefits received under the Social Security Act, that existed, payments to victims of war crimes or crimes against humanity, or payments to victims of international terrorism or domestic terrorism. Now, we don't need to focus on the war crimes and terrorism part. In essence, the only times we ever didn't calculate any source of income into the means test was Social Security income or Social Security disability, things that came from Social Security Administration. Now, this doesn't mean there wasn't other exemptions to the means test. We just talked about one. So you might be exempt from doing the means test altogether if you were National Guard or Reservist, or maybe the majority of your debts are non-consumer in nature. In other words, 51% or more of your debts were business related. You wouldn't do the means test. But if you're doing the means test, what do you get to leave out? And the answer in a nutshell was only Social Security disability. Well, if you haven't figured out yet, I consider it absolutely ridiculous that VA disability, that you could be injured, possibly very gravely, in the service of our country in the armed forces, and your benefits that you earned are counted against you, but an individual who receives government assistance and Social Security disability just as a result of being an American citizen who didn't get this through military service gets an exemption. That's really silly. That's not a fair standard. That's hypocritical. And I've actually brought this up to our congressional delegation previously, talked about it with their staff members. And so I'm very pleased that now we have passed, and it is the law of the United States, that payments made related to DOD or VA disability are exempt from means test calculations. You don't have to count those in. So specifically, any monthly compensation, pension, pay annuity, or allowance paid under Title 11, 37, or 38 in connection with a disability, combat-related injury, or disability, or death of a member of the uniformed services, except that any retired pay excluded under this clause shall include retired pay paid under Chapter 61 of Title 10 only to the extent that such retired pay exceeds the amount of retired pay to which the debtor would otherwise be entitled if retired under any provision of Title 10 other than Chapter 61. Well, that's a mouthful. What's that? Like I said, you don't have to count disability payments, VA or DOD or VA, and if you're receiving retirement pay based on medical retirement, you exempt that to the extent that that portion was for the disability, but you don't take out the military retirement component. So if you get in both military retirement, maybe you're fully retired and you get VA disability, or you're receiving just retirement based on a medical discharge, then you're going to figure out what component of that is exempt and you take that out. And this, of course, also depends on your percentage rating because that affects for individuals how much of each they can get. We don't have to go down that rabbit hole other than this is wonderful. I probably consider this personally the most important and the most valuable of the 4 laws we're going to talk about today. It's balancing an equity that should have been done a long time ago. I don't really understand how this oversight has always existed, and I'm glad this happened. This was called the Haven Act, Honoring American Veterans in Extreme Need Act of 2019. All right, folks, we're up to the last one, 3 of the 4 new laws, but this is the biggest one. I mean, as far as complexity and change, not necessarily, I think, the most important, but it is the biggest one, and that's why we're going to have the most time left on our program to talk about this. Also, want to mention real fast, folks, because we're about halfway through the program, if you're on our social media, if you're tuning in through Facebook and you're watching the Facebook live feed, we're trying something new because of the interactivity of this and because of the interest in today's program. We've got a little poll up there. It asks which of the new bankruptcy laws will help people the most, and then it's got a little description of the 4 different laws we're talking about on our program today. You know, I'd be interested to know what your opinions are. I just shared that I personally believe that the 2 that support our armed forces is the most important, but namely, I think number 1, if I had to pick out of the 4 what's the most valuable of all these laws, to me, it is the protections of VA disability payments to armed forces members and excluding that from means test calculations. That's my favorite. What's your favorite? Tune in. Hop on the social media, take the poll. I'd like to see what some of those results come back at. But now to the last one. This last one is a whole new subchapter 5 of title or chapter 11 of United States, Title 11 of United States Code. So chapter 11 is reorganization. And we've talked about this in some prior programs. It can be used by businesses or individuals, but it is far more complex as a form of bankruptcy than any of the other chapters we would have talked about. That the other chapters are designed to be simpler, easier, and straightforward. Chapter 12 is a form of reorganization, but only available to farmers and fishermen. Chapter 13 is not available to businesses. It's only for individuals. So that's the first thing. If you're a small business, you can't file Chapter 13. And even if you're an individual, there's limits on Chapter 13. It's got debt limitations. If you have over about $415,000 in unsecured debt, you blow the debt limits for a Chapter 13, just like the $10 million limit on Chapter 12, as we discussed a while ago. And you think, man, that's a lot. Wow, there's no way I could have more than $400,000 in unsecured debt. Oh, $400,000 in credit cards. Well, but remember, that's all unsecured debt. That could be student loans. That could be taxes. What if you are a highly educated professional who also encounters some very difficult financial times? You're a doctor or maybe you're another lawyer. You've got $200,000, $250,000 in student loans. Then you've got some back taxes, and they are, whether they're priority or not, that's unsecured still. Doesn't matter if it's general unsecured, it's just unsecured. So you got $50,000 in back taxes, you got $250,000 in student loans. Folks, that's only another $100,000 before you hit the debt cap. So it's not nearly as high as you might think. You can price yourself out of a Chapter 13 under certain circumstances and below those debt limits. And so the problem then meant you were looking at a full-blown Chapter 11, where the filing fee is $1,717 just to file the case. You're going to burn through a $10,000 attorney retainer in a second. The biggest bankruptcy going on in the state of Oklahoma right now is White Star. That is an energy company formerly owned by Aubrey McClendon. Folks, the attorneys in that case are billing it up to almost $1,600 an hour. How quick do you think those attorneys' fees are going to rack up in that thing? So my point is Chapter 11 can get very expensive, very complicated, very quickly. So the problem with that, and I've discussed this on our show when we talked about Chapter 11, is that creates a lot of barriers to entry for a small business historically. Some of the barriers are, let's just go back over them. I think there's 3 problems with an individual small business filing Chapter 11 before the enactment of this law. Number 1 is cost barrier. We sort of just touched on that. You may not have the money and the funds to make this work out. You're a small restaurant, you're a mom and pop shop, you go to an attorney and they tell you, you need $10,000, $15,000, $20,000 retainer. They don't have that. There's no way they can come up with that. In addition, historically, typically, equity holders, the ownership cannot retain control of a business in Chapter 11. That the stock's going to get canceled, that the ownership's going to get taken away, the business ends up in the hands of the creditors. And in fact, that is a very specific rule when we talk about confirmation of plans for Chapter 11, that you can't have one class retaining any value or property or receiving a value below another class. And so what that means is, why would a small business, locally held, 2-member LLC, go to all the time, trouble, and money to file a Chapter 11 bankruptcy if they still know that that company is going to get taken away from them anyways, that they're not going to keep it? Now, there's some ways to pull this off, and we've done it, and other attorneys do it. But if you have objections from creditors and you end up having a fight over the plan, it can be very, very difficult and very unlikely you're going to keep that business still. So that's a problem. And then the last thing is there still has to be some vision forward. You have to have a plan, not just in the literal sense legally of how do you form a plan statement in Chapter 13 or Chapter 11, but what are you going to do? If you didn't make money before, how are you going to make money now? What are we going to do? Those are the big barriers to Chapter 11s. And before this new law, it made it hard then for for debtors that were small to figure out a way to go forward. But so this new law creates a section just for the small business debtor. So first off, who is a small business debtor? Well, the debt limit is $2.7 million. That's the number that we're going to be focused on. If you have less than $2.7 million in total aggregate debt, you could file under this specific provision of a small business. Now, business doesn't mean it has to be a legal entity type. You can still be an individual and file a small business procedure, Chapter 11. So I mentioned that you can't do a Chapter 13 if you're over this certain $400,000 number. Well, if you got $1 million debt, unsecured debt, now this is available that helps you tremendously. You could do a small business Chapter 11, and you don't have to go through the process of a huge, big, full-blown Chapter 11. A couple other things. You don't have to do a full disclosure statement. You do just a plan. That you do hold a couple details. So there's no disclosure statement in this special provision. You have to follow the same requirements that previously existed for what was previously defined as a small business case. And that means that when you file the bankruptcy petition, you're going to attach to it your balance sheet, statement of operations, or profit and loss statement, a cash flow statement, and your tax return. You've got to go to a meeting, we call it an initial debtor interview, with the local United States trustee's office. And then, of course, all the usual things. You got to make sure you file your post-petition operating statements, monthly operating reports. You've got to make sure that you're filing your taxes. You're doing some of that stuff. So you're going to do that, but there's a whole new section here. Creates a required status conference. Within 60 days of the filing of the case, the court's going to hold a status conference to get a better understanding of what's going on with this case. Where's this debtor at? What are we going to do to get them in and out of this Chapter 11? Who can file a plan and when is hugely different. In a normal full-blown Chapter 11, either a creditor or the debtor can file a plan, and they have to do it unless extended by the court within 300 days of the date of filing. In a previous rules small business case, the debtor had an exclusive 180-day period to file, meaning they didn't have to file one within 180 days, but after that, creditors could file one. Now, the court can set timelines and scheduling rules differently, but normally you had a 180-day exclusive period. In this new chapter, subchapter 5 of Chapter 11, the debtor is the only person who can file a plan, period. Creditors can never file a plan. And they have to do it within the first 90 days. So this is designed to get you in and out. This is not meant to be long, lengthy, take 2 years. 90 days, the debtor's got to file a plan. No one else gets to file a plan. If you haven't figured out yet, this is shaping up to look a lot like Chapter 13. This is basically a small business version of Chapter 13. Or Chapter 12, because what we're going to get to now is very much unlike a normal Chapter 11, all of your payments are going to flow through the trustee's office. Again, just like in Chapter 13. So when you distribute the funds to the creditors based on whatever the plan provides, you pay the trustee, and the trustee is going to pay the creditors with those distributions. That's completely different than Chapter 11. Normally in a Chapter 11, the debtor remits all the funds and keeps all the records on their own. This states very clearly, payments and funds received by the trustee shall be retained by the trustee until confirmation or denial of confirmation of the plan. If a plan is confirmed, the trustee shall distribute any such payment in accordance with the plan. You're paying the trustee. Like I said, very different, but hey, good to know. It's interesting. New law. Nobody in the United States has filed a case like this yet because you can't even do it yet. When it comes to confirmation of the plan, it has to be 3 to 5 years, 36 months to 60 months. Sound familiar? Yeah. Why does it sound familiar? Because it's the same as a Chapter 13, just like we've talked about in our program before. So like I said, this is very much shaping up to be the business version of Chapter 13. So plan payments, length of time, what do you have to do in your commitment period? 36 to 60 months, 3 to 5 years. And equity holders keep ownership. You don't have to provide in the plan that you're going to lose control and ownership of the company. You can be a small business owner. You can be an LLC. You can do this. You can reorganize, and you still get to keep your livelihood. It eliminates the absolute priority rule that otherwise exists in bankruptcy in Chapter 11s. And so it changes some of these ways we do what's called cram down. It gets rid of paragraph B of 1129. But so this is huge. No absolute priority rule. Don't have to get rid of equity. We make payments through the plan to the trustee. Got to be 3 to 5 years. Also, though, we've talked about a lot of carrots. Here's a bit of a stick. You don't get your discharge until you've fully consummated the plan, and they define fully consummating as completion of all of the payments under the plan. Normally, if we're doing a Chapter 11, you're going to get your discharge after confirmation, even though you may not have started making the payments and done everything yet. You're going to get your discharge and move forward, but then you're still going to continue to do what's required under the plan. Here, this is just like an individual's Chapter 13, where you've got to reach the finish line to get the discharge. Now, don't get me wrong. If you're a Chapter 11 business and you don't make all the payments, the creditor could come back to revoke your discharge or to make changes. But here, you got to get to the end and then apply for a discharge, ask for that discharge based on everything. So this is going to be something that's going to be studied. This is going to be something that's going to be utilized. I expect that it's something we're going to see in our practice because there are many individuals or small businesses, and those individuals have small businesses, whether you're an LLC, whether you're a sole proprietor, whether you're a DBA, that need relief, that need to find tools forward that didn't exist previously. And so I'm very happy to see that Congress has acted in a pro-individual, pro-debtor fashion and created 4 new laws that are going to help people. Not businesses, not banks, not Wells Fargo, not JP Morgan Chase, people. I think these 4 laws are going to very much help individuals. $10 million hugely increases, almost 2.5 increase on the debt limits for Chapter 12, opens the door to a lot of farmers who may be in difficult financial distress. We talked how Kansas has seen a 50% increase. They have the second most Chapter 12 filings in the United States. Oklahoma leads the country in the increase category with a doubling. Hopefully this will now afford more individuals relief. Folks, this has been a wonderful episode. It's been very informative. We've talked about all the new bankruptcy laws that have come down in the last week, signed by President Trump on August 23rd. As always, if you have questions, don't hesitate to call or email me. This is Jason Sansone with The Legal Breakdown. Have a great week. Stay weather aware. I hope everybody's recovering from all these wins we've had this last week.